Notary Public, trademark agent, the whole lot. So he's up in the Cork offices in Cork and in Dublin. So he's going to talk about the new Mediation Act there today. Okay. Okay. Thanks, Bill.
Billy Christian introduced the Oscars about 8 years ago, and he said, "Welcome to the Oscars Awards ceremony. 4 hours of entertainment packed into an 8-hour show." So I'm going to try and reverse the proportions. I have done a 20-minute version for the judges, 100 of them, on the 17th of April. I've done 1-hour versions, I've done 2-hour versions. I went to Monaghan and they asked me to do the 2-hour version, 1 hour, and give them a cert for 2. I said that was something to get up with very easily. So I'm booked for 2 hours. In Monaghan they asked me to do the 1 hour. I was there for 3.5 hours because they had so many questions. But they were a very tough audience. So we'll see how we get on. The Act came into force on the 1st of January. The rules came into force on the 22nd of January. On the morning of the 22nd, we had somebody at the Central Office issuing proceedings. And they were told, you have to file your Section 14 declaration with that. And they asked, what are you talking about? And said, new rules today, you have to file a Section 14 declaration, Mediation Act with that. Oh, do you have the rules? No. Are they on the website? No. Does the department have it? No. So we have to file a declaration according to rules that nobody has yet. Yeah. So I rang Rosemary Horgan, our ex-solicitor colleague turned president of the district court, on the basis that Rosemary would have drafted the district court rules. She didn't have them, nobody had them. Got them, sent them to every office in the country on the 23rd. And I did it by county, I have a mailing list. So somewhere in your inbox for the general office email is new rules are enforced today, bracket, even in Kilkenny, close bracket. And I said, if you're interested in more information about mediation, I have a pack that as a mediator I give to solicitors that they can give to their clients to answer most of the questions the clients are likely to ask. If you want it, let me know. If you're not interested and I'm taken off the mailing list, let me know. I got 4 categories of replies. The first one was, take me off that bloody mailing list. The second one was, gee, know nothing about these rules, thanks very much, that's very good of you. Please send me the information pack. The third one was not unheard of and not unprecedented. Please send me the information on meditation. The fourth one I've kept because it's a real beauty. I'm going to use it for suitable embarrassment purposes at some point. Please send me the information on medication, I need it. So I sent out the information to the latter 3 and I said, if you're interested and you want a CPD, give me a shout. Since the 26th of January, when I started in Tullamore, County Offaly, I have done, today is number 25, believe it or not, in about 13 or 14 weeks. I never expected people would be interested in CPD, let alone mediation in particular. And then, of course, as you've seen in the past fortnight, suddenly it's become the hottest topic going in terms of medical negligence and kind of state cases, etc. When I went to Tullamore, I launched straight into the nitty-gritty, but I was told, we'd like to know who you are, so I should have introduced myself. So the first 2 slides are me introducing myself. That's what I call the trophy wall. Now the trophy wall is relevant because there's actually a statutory obligation on mediators to tell everybody how wonderful they are. So I'm going to tell you how wonderful I am by telling you I have a trophy wall, and there are the various bits and pieces. As Matt has said, I'm a solicitor, trademark agent, notary public, accredited mediator, chartered arbitrator, etc. Pat Dorgan, our incoming president of the Law Society, when I was appointed as a notary, stopped me in the street because Pat and I trained together in the same small 8x8 foot room as apprentices, and he said, "It's true you appointed a notary?" And I said, "Yes." He said, "I know all those degrees from the college, and you went to The Hague, and you were in Salzburg and studying all these places. It'd be wonderful if you ever get a client." So, you may know me, certainly Fiona knows me best from the world of insolvency. I feel like Doug McClure of The Simpsons saying you may know me from, because I do a lot of insolvency work and bankruptcy work. Equally, I've written on lawyers' professional negligence. You do not want to have to read any of my books out of personal interest, whatever about personal or professional interest. But I don't sleep very much. I sleep about 4 hours a night, and my wife is a very light sleeper. So I get kicked out. I don't watch TV, so I end up writing books. I'm currently working on the 9th one for the accountants, writing a book on ADR. So I'm writing with a guy named Keith Kelleher, who's a quantity surveyor, not a lawyer. So it'll actually be intelligible to people in English. Son of one, my father is dead, God rest him. My mother is still to the good. A brother of 4, husband of 1, father of 3, an employer of 400. Now anybody looks up the law directory and they see that there's only a handful of solicitors in the office, wonder how the hell can that be. I'm a director and shareholder of 20 different companies, and I'm not the legal services provider to all those companies. So wearing the customer, the client hat, I understand that what clients want is you to do it faster, do it cheaper, and do it better. And mediation, I'll show you how you can do it faster, cheaper, and better for the client, but actually possibly make more money out of it. Equally, my mother sent me to the Scouts 51 years ago. She felt I needed feeding up, and I did get fed up, literally. She thought that the diet of baked beans would do me good. Now, obviously, this was long before Mel Brooks's Blazing Saddles, and she hadn't factored in the prospect of beans diet for 8 young fellas in a tent. It was all young fellas in my day. But here I am 51 years later, I'm still involved in the Scouts, and I still hate baked beans. But that's relevant from the point of view of badges. Scouts collect badges, mediators collect them as well. I had what they call a health episode 2 years ago, so I was advised I had to take up some kind of healthy activity. When I wrote the Scouts, I was never known for physical activity. So I've actually taken up rowing. So that's where you'll find me on a Sunday and a Saturday, and during the week when I'm not around. And that's how far we get. I introduce myself these days as a Limerick-born, largely Dublin-based, Cork resident, with friends all points north of the Fastnet. And I've literally been out there. So, we've been asked by the Law Society to mention workplace well-being in the course of all speeches, so this is it. That's an extract from the Gazette this month. If you were looking at the Gazette last month, I did a piece on having to think, it was the way I titled it, about having time out and thinking. Because what landed me with my health episode 2 years ago was, with all the insolvency work, I took on 480 cases in January of 2016 when they introduced an appeal mechanism. Again, Fiona is intimately familiar with the adjournments that are necessary in it. And between January and September of 2016, I had 5 Sundays off with 12 to 16 hour days every day. And literally I keeled over one day, ended up in hospital, lost 2 stone in the process. I learned that you have to have regard to Mel Brooks' silent movie. Does anyone know the one word which was spoken by Marcel Marceau, mime artist, in Mel Brooks' silent movie? Hazard a guess? He spoke the word no. I had to learn to say no, because I was taking on too much for people. While I'm doing the 25 CPD sessions around the country, someone has to actually do the job. I get wined and dined and put up in fancy houses like Butler House by a local bar. That's my partner John Lane, so I have to give him credit every time where he'll give out about me. They say that you need in any business a finder, a minder, a winder and a grinder. The finder is the Gerald Keanes of this world who will go out and do the Rotary, the sewing club, whatever it is, get the clients in. The minder will never do that, will never be seen giving a talk, but it's great to mind the client when they come in. Customer support, the after sales service, whatever way you call it. That's John. John would hate the idea of having to come and give a talk. And then you have the winder, is do you want fries with that? Con and herself are getting starting off in practice. Someone said, oh, the lawyer's worst clients under the sun, to have work that for yourself. You need a partnership agreement, you're employing staff, you're going to need employment agreements. All this hard work is going to kill you if you want this. So you need an enduring power of attorney, you need the will. You want fries with that phenomenon. And then the grinder is the homicidal, anti-social bastard you keep in the back room, who's great to get through work, but don't ever let them talk to a client. And there's a bit of that in all of us, but that's what you need. So John is the minder of the practice. That's the advertisement, you can see that in your own time. This is only a short 352 slide CPD presentation. It's a cure for insomnia if you suffer from it. I'll leave you do it in your own time. But they're the ads. That's John's happy face, by the way. When I was out doing one of these talks, John had to go up and collect an award for till he got it for Northside Business in Cork, and that's his really happy face. But I mentioned about being the companies, if you want to look them up, if you want to VisionNet or one of these company sites, and you search for me, you'll find the 20 companies that I'm involved in. So, what do I actually do? I'm best known for insolvency, still do a lot of it, but there's a lot of people in the office doing it. I now mainly do ADR, which is alternative dispute resolution, professional indemnity insurance claims, because now there's a lot of our colleagues who, when faced with claims and being threatened with being sued, they turn around to the insurers, and the insurers, if they've got a small income pool from the premium that they're collecting, it's actually cheaper for them to pay one of the, what I call the glass palace firms on the quays in Dublin, or the one big firm in Cork, known affectionately in the trade as Ronald Lee, not German, it's something running with Vernon. It's cheaper for the insurance companies to pay them 10 or 15 grand to get them off the hook and not pay out on an indemnity free. So I end up rowing a lot with insurance companies to make sure that our colleagues get covered. And then representation of colleagues. I do a fair bit of representation of colleagues in the Law Society. And one of my claims to fame is there was a colleague in the West, Dan, who was a finder, great at bringing them in, but he wasn't too good at the old paperwork. He never got around recruiting or finding a partner who would be a finder, with the result that on an audit by the Law Society, they found over 100 grand's worth of unstamped deeds, and that's the interest and penalties I'm talking about. Not just the core stamp duty, the interest and penalties was over 100 grand on unstamped, unregistered deeds. And there was also evidence of a few creative works, if I can put it that way, which didn't match up with some other documentation. So poor Dan anyway got struck off. And I did the appeal all the way to the Supreme Court for him, and I persuaded 3 judges of the Supreme Court that the President of the High Court hadn't given him a fair trial. Because I don't know if any of you remember Luke Byrne in the Start office in Cork. No? Luke, he's gone, he's transferred out to social welfare or somewhere now. Luke was a very forgiving character, and if you put any kind of a Clonloss story at all to Luke, he'd forgive all the interest and penalties. And this was all 2009, just after we'd gone over a cliff. Then President of the High Court freaked when he found out that the Revenue had forgiven over 120 grand in interest and penalties. And he said to the Revenue Solicitor, I want you in court to explain this. The Revenue Solicitor very politely told him, you can take a choice of any 2 adjacent fingers in the one hand, moving in an upwardly mobile direction. It's nothing to do with you. The Revenue have discretion, we've exercised the discretion. And they weren't too pleased with Luke. Luke got transferred to social welfare or somewhere out of the Revenue. But the President blew a gasket. Unfortunately, the gasket hit poor Dan. He was struck off and went to the Supreme Court, who agreed he didn't get a fair trial. So I have argued cases all the way up. Now the point of all of this is not to say how wonderful I am. It is simply to point out I'm not afraid of going into court and having a fight and litigating with people. By the way, there's no truth like the introduction of the Court of Appeal just to screw up my record. I've fixed dates for hearings in the Court of Appeal, but I haven't actually fought one yet, but we might get there. That's a case I did in the Supreme Court, if you want to look it up. I successfully persuaded 3 judges of the Supreme Court, Flaherty, Barron and Murphy, that a seat in a theatre or a place of public entertainment is not something you sit on and place your body weight on and are supported by. It's legally the airspace you occupy from the moment you enter the building to the moment you leave. And if you're really anally attentive and interested, I'll tell you after why it was worth arguing that in the Supreme Court. Equally, I've been a plaintiff. I took an assignment of a judgment mortgage that a client got for a successful costs order. The client unfortunately died, and the widow assigned the judgment mortgage to me in consideration of the costs that were due to them. And that's a case on whether assignees can pick it up. So, I describe myself as the repentant lawyer who, having worshipped in the satanic church of litigation for over 25 years, converted to the one true church of mediation. And for the past 13 years, I felt like the Mormons who come knocking saying, we've come by Jesus. And the householder says, by Jesus you can go. But now people are actually interested in beginning to listen, hence the 25 CPD seminars. I'm a member of the Law Society ADR Committee. I'm on the Council of the Mediators Institute. I've just finished up a year as chairman of the Chartered Institute of Arbitrators, which is an unfortunate statutory title that's granted by Royal Charter, because we now have more adjudicators, mediators, conciliators, cogitators, ruminators and defecators than we have arbitrators. So it's a very broad church, just in case you think. That was me when I qualified in 1983. I became a member of the Chartered Institute of Arbitrators in 1986, after 3 years qualified at the time, and I've done arbitrations. That is a case where somebody saw fit to challenge an award I gave the Chartered Institute administer a scheme for the Society of the Irish Motor Industry. If you buy a car from an SIMI, Motor Industry Association member, it goes to arbitration, and there's a cheap and cheerful arbitration scheme. We get about 500 quid to act as an arbitrator, and I awarded a punter €6,235, and someone saw fit to go to the High Court to try and challenge it. Now, there was a partner on David German who was active in the garage, and he told me, he said, this is bonkers, you're going to the High Court. If you want to do it, we'll do it, but you have to put 40 grand on the table. And the guy did. So he trumped up 40 grand to go in. Brian McGovern nearly had a heart attack when he found out what his court has been taken up with. So, I'm prepared to get down and dirty. It's a dumb beating, is what it is. And I'm prepared to fight. That's the moment of conversion I talked about the conversion to the one true church of mediation. This bit is important. Remember the scouts and the merit badges I mentioned earlier? You don't, because you just came in.
Sorry about that.
As a mediator, you have to tell people about your qualifications. You have to show them what training you've done. You have to mention the number of mediations you've done, etc. Now, the whole thing is confidential. So how you're supposed to know when someone tells you, oh, I've done 200 cases, whether they have or they haven't. There's no actual method of verifying it. It's all confidential as well, behind doors. So unless you know somebody who's actually been in a case where somebody is mediated, you can't verify it. It's the same with arbitration. It's completely different from court, where you can see how somebody performs in court. So I can tell you I'm the best in the world, but how do you know? And that was the offer. Be careful what you wish for. As I say, I offered to do the CPD thinking nobody would want to do it, and I get the credit for the offer, but here we are 25 later. That list, by the way, coming up, that was when I had done 18 and I made a slide of it. I haven't had time to do the thing up to the 25. I've even been to England, because we now have a statutory basis for mediation. They don't. They have a much more developed case law body than we have. And I'll explain about the case law later on, and that's going to be the thing that really is going to bite everybody in the proverbials. Because there's now a statutory basis for judges to refuse to give a successful party their costs. And worse, if you go to court, if you insist on going to court, and you get something in court that you could have got as a result of straightforward settlement negotiations in the courthouse, whether it's up the road here, or in the forecourts, or down in Clonmel, or wherever, you can not only be refused your costs, you could be made pay the costs of the unsuccessful party. And it's going to happen. One or other of the judges is going to do it. On the 17th of April, I gave a talk to over 100 judges up in Church Street in Dublin on that exact point, on their powers in relation to costs. And that is the line-up. The Chief Justice, Paul Gary, Chairman of the Bar Council, Paul Gilligan, who's about to retire tomorrow from the Court of Appeal, and myself. Paul Gary spoke before I did, and he spoke about the Act in general. I had a great pleasure in standing up after Paul McGarry, Senior Counsel, had lectured everybody on the Mediation Act, and I said, I'll have a word with Paul afterwards. He made 2 mistakes in his presentation, and I ploughed on. In fact, he made 6. I might have embarrassed him too much, or he'd never forgive me. But that said, I'm having a ball. I really enjoy it. And very quickly, back to the bit about the wellness. We've been asked to promote this message as well in any talks we give. If you can get the intersection of what you love doing, what you're actually good at, and what pays you well, and if you focus on all that, it's a win. If you do what you love and what pays well, but you're no good at it, it's just a dream, because you're no good at it. If you do what you love and what you're good at, but it doesn't pay, you might be very happy, but you'll be poor. And if you do what you're good at and what pays well, you'll be rich, but you'll be bored, because you don't love what you're doing. Right? Up to you where you pin your mark. All these slides will be sent on to Matt afterwards, and you can share them. Equally, I have a Dropbox folder with more information about mediation than you would ever want. It's not a cure for insomnia for one night, it's a permanent cure for insomnia. I'll make the Dropbox connection available as well, and you can download the stuff if you want to. There is a pack in there of information you can give to the clients. Now, when people contact me about acting as a mediator, I can tell within about 30 seconds whether they've been down the road before and know something about it, or they're really feeling about, and they've just learned to spell the word correctly, and they're making the call. And I'll give you the pack, knowing that they're probably 1 page ahead of the client in terms of reading up on it. But that's fine too. The business case, that's one board snip. The older members of the audience will remember when board snip actually came out. And this was a comment on a case where the Commissioner for Airline Regulation took a cut off Dublin Airport Authority, and there was over £500,000 spent on legal fees. No objection to the pension funds of lawyers being approved, being one, but when Board Snip said this was a disgrace of public money, when what was at issue wasn't a legal precedent, wasn't a hugely important issue, it was just a commercial wrong, and said you could have sorted this out. You don't have to stand, I appreciate the 72 stone, it's great. So, great quote. Remember I mentioned about the arbitration case where I gave £6,000. Another £6,000 car case where costs went off the wall. A case in England. £6,000 car went all the way to the Court of Appeal. The costs taxed at over £100,000 sterling. on the case. And the judge said, "You're daft to be here. You should have tried mediation," and quote, "The results are astonishingly good." My favourite quote out of the case is this one. The parties were, quote, "completely cuckoo not to have," and that's a judicial pronouncement. You can refer to that when you're talking to your clients. Judges have said you're completely cuckoo not to mediate, because some clients will insist on going to court. That's fine, but they may have to end up paying for the privilege. And I'll cover later on why it's important that you put it in writing to the client and you get the client to sign off on, yeah, you've told me all about that fuzzy-wuzzy mediation stuff. Not interested, I want my day out. Because when they make the complaint to the Law Society, when they get hit for costs, or they don't get their costs, or when they actually sue you, and you're explaining yourself to the insurance company, you get to waive the acknowledgement that they have signed saying, "I accept that you have advised me." It used to be that if you suggested mediation, they're windy, they have no confidence in the case, we'll plough on, we'll see them at the doors of the court. Not anymore. It's not a sign of weakness to suggest mediation, it's actually common sense. And again, that's a judicial pronouncement on it. Results astonishingly good. Try it more often. Now, you'd be surprised at what can come out of cases. I'll give you an example. I had a case 5 years ago where I mediated for two brothers. They were running a very successful multi-million company. Older brother was the finder. He was the guy who went out, brought in the clients. Younger brother, almost on the spectrum, actuarial in his thinking, he was the figures man. And he suddenly announces, the business has peaked, it's not going to grow anymore, I want to sell up, I want to sell the company, I'm going to move to the States, I'm going to set up in business in the States. And the older brother said, "What are you talking about? We have another 20 years of growth in this business. We're only getting started." They started exchanging memos. The older brother was an Albert Reynolds fan. Now, Albert Reynolds famously had an expression that he was a one-page man. He didn't want longer than one page. The older brother would give 1 or 2 page replies to the 20-odd page memo that the younger brother would deliver, full of complicated financial projections and all sorts of things. This went on for 18 months. They both consulted solicitors. They were about to present a petition. The younger brother was about to present a petition to wind up the company in the High Court in order to get the sale that he wanted. And the older brother was banging his head saying, "This just doesn't make sense." So they agreed to mediate. I was asked to mediate. And part of the mediation process is, the whole thing is confidential. Anybody here who did the junior cert? Just looking behind, yeah. I did the intercert, right? But you remember your junior cert, intercert maths, and confidently you had your sets. If you take the whole thing as one big set, it's confidential. Nothing gets out in terms of disclosure or information unless there's a settlement. Within that you have subsets. And the idea is that within each room, if you've got 2 rooms for the 2 parties in a mediation, and the biggest mediation I ever did, believe it or not, was for not too far from here, 18 parties to it. Now they were in camps, there were 6 camps, but we had 6 rooms for the 6 camps in the mediation. And surprise, surprise, it didn't work out. But everything within that subset is confidential, and it doesn't come back out unless you're given permission to do it. So you go in and you try and establish a relationship with somebody that they actually trust you, and they tell you what's really going on. And they lay out all their cards on the table. Now in negotiations, if you go down the street and you go to the courthouse and you're negotiating, if you know your colleague well, and you know that they always start off with asking for twice what the case is worth, you can say, "For God's sake, would you cop yourself on?" I did that 20 years ago. A certain senior counsel who visits this neck of the woods as well, who would be known for medical negligence cases in particular. I won't go any farther than that in identifying them. But 3rd week of the High Court in Cork, 2 weeks of the proper High Court, a week of appeals, 4:30, settlement talks. I'm tired, I'm not quite cranky. All I want to do is get it sorted and go home. He comes out and he asks for twice what the case is worth. I was for the defending insurers. And I said, "John, it's true what they say about you." And I turned and walked away and said, "What did they say about me?" I said, "John, you always do the same. You come out, you ask for twice what the case is worth. We spent the first hour flapping around until we get to something that's reasonable, and then we start talking. Tell you what, you go into the bar room, talk to yourself in the mirror for an hour. I'll go away, I'll have a drink, I'll come back in an hour, and we can start. How's about that?" And he was so flabbergasted, he went straight to the reasonable zone. But that's where you know your colleague. If you don't know your colleague, and they're a good poker player, you're bluffing. With the mediator, it's a bit like Humpty Dumpty on the wall. You get to see both sides if they level with you. Now, the younger brother levelled with me. And he explained to me the real reason he wanted to wind up the company. And it had absolutely nothing to do with the company. I did a traditional Irish romance 15 years before I got married. This guy did 15 weeks in his 40s. His wife was in her 30s. They tried for 6 years to have kids, naturally. Didn't work out. They went through 6 rounds of IVF. Normally you only do about 3. They did 6 because they could afford to pay for it, because the company was so successful. Didn't work out. He rationalised, very rational character. If they went through the adoption board and Board Tala system here, it takes 7 years. And then there'd be no Irish kids, there'd be no Ukrainian kids, no Vietnamese kids available, etc. Whereas if you go to the States, they will live in your ear and you will be under scrutiny for the best part of 2 years. But at the end of 2 years, if you've ticked all the boxes, and even if you sign up as a membership of the NRA, you can have a child in the house within 2 years. That was the driver for winding up the company. But he wouldn't tell his older brother for fear the older brother would reject the idea and say no. So he asked me if I'd do it. And I went and said, look, he's told me this is the real reason. The older one said, well, stop the lights. If we have to, we'll do it. But can we look at other stuff? They sold some assets, gave him all the money. He went to the States, set up a very successful business there, remained as a non-exec director, remained as a shareholder, and last year they sold for 5 times the valuation at the time of the mediation. Now, if they'd sold it on a fire sale on foot of a petition to wind up 5 years previously, it would have been a fraction of the value. And that's a real win-win kind of a scenario. That just explains it. This is a quote from Wall's construction. This was Kelly just talking about the fact that the system we have in litigation, it started in the 1870s when you got the merger of the courts of equity and the courts of law. We have 7 different ways of commencing proceedings in the High Court. We have very complex systems, and they haven't actually revised the whole thing. This was in the context of personal injuries mediation. Now, I have at this stage addressed over 1,000 solicitors around the country. Would you care to hazard a guess how many have told me they've ever actually utilised the 2004 Act provisions and mediated a personal injuries case? There's a clue. 1. Right? I've done 1, and it wasn't the one that the person up the country actually identified. It's there since 2004, hasn't been used at all. 2010, they set about revising the whole thing. There's going to be a huge revision of the court system coming in the next couple of years. Frank Clark is very hot on this subject. He's got Peter Kelly on it as well, and anybody who's dealt with Peter Kelly will know that when he gets his teeth into something, he goes at it. They're going to introduce, like the UK system, where you've got to disclose everything in advance, witness statements in advance. Everything is going to be on paper beforehand. The idea of particulars, giving you the broad headlines of what the thing is about, you're going to have to get into a detailed statement of exactly what the evidence is going to be. And it's going to take the surprise out of it. There'll be no more Dallas moments when the door at the back of the court comes open and somebody comes in with the veiled hat and whips it off to get up in the witness stand and give some devastating evidence back from the dead. None of that will be allowed. Part of it is they're pushing big time. If you get Frank Clark down at some stage, he'll tell you, well, money for new courthouses and renovations and the whole lot. They don't have money for judges, they don't have money for registrars. The IT system is Windows XP, which is no longer supported and it's constantly crashing. They're getting hacked on a regular basis. But the government, for some reason, will give them money for companies and won't give them money for IT systems. Because they estimate to do it properly is going to cost something like 20 million to revamp the computer system. Anyway, they're pushing big time to have the cases moved out of the courts, and the judges are supporting it. The main people at the moment, Frank Clark, Chief Justice, Paul Gilligan, at least until tomorrow, because he's retiring tomorrow, Peter Kelly, Court of Appeal, back as President of the High Court, Keenan Johnson, Circuit Court, Rosemary Horgan, District Court. And they're all members of a group called GEM. Now, this is not some secret cult, this is judges for mediation. Now, judges in a European sense is a much wider expression, includes all sorts of tribunal chairpersons, etc. But they're very much in favour of the whole thing. And they organised the gig that I spoke at on the 17th of April about what judges can do under the Act, and particularly, as I said, I was speaking about the costs implications of it. There's nothing new in mediation, right? The Book of Job has bits about mediation in it. Voltaire talked about it and taken the lawyers out of it. Now, he had a rather radical solution. Shakespeare as well has a phrase, he has a phrase for everything. One of his is, let's kill all the lawyers. Not that it had nothing to do with mediation, but he would take it out. Teddy Roosevelt mediated the end of the Russia-Japanese War, if you didn't know that. I'm a history buff. I put this slide up when I was up in Sligo, and last week as well up in Leitrim, because Michael Monaghan is a solicitor. He's just won the award for customer service with the Irish Law Awards. And I asked the question, was it really he who was behind the door? That looks like a dead ringer from Michael Monaghan from Sligo, if any of you know him. And that was he the one who really mediated the Good Friday settlement. I got a laugh last week anyway. Deciding things by trial by battle. Does anyone in the room know what the right of trial by battle was?
Wanted to champion the two of them.
Yeah.
Head at each other, yeah.
And legally, you were entitled to call, up to 1819, just under 200 years ago, you were entitled to call to have whatever dispute it was decided by right of trial by battle. And the idea was, you got the biggest, boldest fecker you could get to go out and beat the proverbial out of the other side, and their champion. The theory was that God would be on the side of whoever was in the right, because good will always triumph. That was the legal position up to 1819. And they then abolished it. So then what they did was, they substituted getting the biggest, baddest barrister you could find to go and beat the crap out of the other side. And litigation depends on a negative inquest process into what happened in the past. And you try and destroy the other person's credibility, their legal arguments, their factual basis, their memory of events. So it's a negative, destructive process. The whole idea of mediation is completely different. It's not about looking backwards, it's about looking forwards. You're trying to work out, okay, fine. To use that very technical expression, shit happens. It happened. You can't change the past. You don't have H.G. Wells' time machine. You can always ask the question in mediation, if you could go back and do something differently, would you? And that might lead somebody into apology mode, that might be communicated, that might soften the things and change attitudes. But you're talking about the future. Okay, it's happened. How do we sort it out for the future? What could everybody work with in terms of a solution? That's what mediation is about. Toomey J, another solicitor colleague who went to the High Court, talks about the court system now being inaccessible. People can't afford to go to court anymore. There's too much at stake. And he says that things should be resolved collaboratively if possible, mediation if not, expert decision if necessary, and only as a last resort in this fearfully expensive forum. He was talking about the High Court in relation to that. But Circuit Court is, and now with the scale of costs in the District Court, it's no better. And the FIJ in this case said, you know, in litigation you have winners and losers. You'll never actually have two winners coming out of the courthouse after a judge has given a decision. You might have a winner and a loser, or you might actually have two losers. And shortly after I qualified in 1983, none of those people in the room can beat that, but I had a case in front of Rowan Keane, and he said in his judgment after 5 days of hearing, at the outset, I paraphrase slightly, but these are roughly the words he used. He said, at the outset, I'm going to clarify that I hope the lawyers on both sides in this case have been paid their fees in advance because I'm making no order as to costs. For 5 days, the parties have argued over what everybody accepts is the carcass of a completely insolvent company. And I do not know what jewel there is in the rough in this company that people have fought so bitterly to try and get control of it, but that has eluded me. Meanwhile, and he pointed to the back of the door of the court, he said there are people with real grievances and real concerns baying to get through the doors of the court. So no order as to costs. That was a loser-loser. Again, you know, in this case, school of yoga, the FIJ said, you know, look, fine, you're entitled to come to court, but given what was at stake, it was ridiculous to be coming into the High Court litigating these things. Mediation could be a fraction of the High Court costs. Now, when somebody comes into me and they talk about wanting to go to the High Court, I say, look, bog standard dispute, if you're going to have senior counsel in it, you're going to have to start factoring for a budget of about 50 grand to get to the point where senior counsel stands up and says, I appear for the plaintiff. Senior counsel will charge you brief fees, depending on the case, 10 grand upwards. If you want to try and get a senior counsel to mediate, and there seems to be, even among the Glass Palace firms and the Keys in Dublin, as I call them, the big firms, if you're talking to them about mediation, they seem to default to senior counsel. And there's no logic to it, because we have eminently qualified solicitor counsel or solicitor mediators. I'm not the only one who's out there. But senior counsel will tell you, oh, I can get 10 to 15 grand as a brief fee to be in the High Court, so why should I take a fee to mediate at anything less? The most expensive fee I've ever got as a mediator was 5 grand, and that was a particularly complex commercial case where it involved a bit of preparation beforehand. Normally, for a one-day mediation, with read-in time and the day itself, you'll be looking at a fee for a mediator of about 3 grand. Now, you're not going to mediate the district court claim for the £6,000 car or the €6,000 car. You're not going to be mediating the kitchen island that went wrong or the bathroom installation that was screwed up. But circuit court, high court, yes. Where relationships are important, where interactions between people in the future are important, whether it's family members, neighbours, cattle trespass, boundary disputes, rights away, 117 claims, whatever it is, then it can be particularly successful. Again, the rights of the court previously were limited to just adjourning rules. Sorry about that. That's actually John Lynch, Solicitor, from just up the road. You know, you can waste an awful lot of time, energy and money on litigation, whereas you can have a short, sharp mediation. And you can mediate before proceedings are issued, after proceedings are issued, before proceedings are closed, after they're closed, before discovery, when you're at hearing. I'll show you an example later. There's a case in front of Paul Gilligan. The plaintiff's evidence was in its 150th day when they went out to mediate. And the plaintiff's evidence wasn't finished. It was estimated there was another 150 days in the case. It was successfully mediated in 1 day. Peter Charlton, or not Peter Charlton, he's the judge. What's his first name? I can't remember. Jerry Charlton, I think. Reddy Charlton McKnight in Dublin. He had a row with Kilkenny over a hedgerow, if you remember, a couple of years back. Successfully mediated in 1 day. Dubliners in the EMI scheduled for 6 weeks of hearing. The week beforehand, they went out, mediated, successfully mediated in 1 day. So you'll be surprised what can actually happen. I got a phone call a number of years ago from the AIB Bank in Dublin, and they asked me would I mediate a customer dispute. Now I thought it was between the bank and the customer, and that they said we'll pay the fees for it. I said, well, I need to know who's involved, do a conflicts check. And it turned out actually it was a dispute between customers, and the customers were 4 brothers who were steps of the stairs, as in 2 sets of Irish twins, literally each of them 9 months after each other. They were born within 3 years. And then there was a gap of 15 years with a blessing from God in the form of a 5th brother. Now the business that the father had was a pub. They were all taken out of school at the age of 13, put into the cellar, literally, and they worked their way up from the cellar. More pubs, grew up into the business. The gift from God, however, was sent off to college. He went off to Maynooth for a while, that didn't work out. Came out, got married. He was funded to start 3 successive businesses that didn't work out over the years. The father in his will decided he's kind of got the sub up front to start the 3 businesses, so he gave the core business to all the 4 brothers, and he left a bit of a lump sum for the gift from God. He took a 117 action against the estate on the basis she should have got an equal share. For the sake of the mother, who was still alive, because he was the apple of the mother's eye, the 4 settled. Now all of this happened after a property investment that he persuaded them to get into. And he said, I've identified a property, and he went to the mammy first to make sure she was on site. Sorry, this was their version of it, so paraphrase. Went to the mammy first, got the mammy on site, and then said, property investment, I've identified a property north side of Dublin, perfect for a creche, there's no creche within 4 miles of it, lovely corner site, loads of parking, sorted, and they agreed when pressurised by the mammy, they invested. It turned out, and he said they have a tenant lined up as well, it turned out the tenant was a company controlled by his wife. He did not tell them that there was going to be no rent reviews in the first 15 years. He did not tell them there was not FRI lease. He did not tell them that the terms were extremely advantageous to the tenant. And every time they tried to raise something with him about it, he said, oh no, we've talked to the wife, it's her company, I'm nothing to do with it. Anyway, unhappy differences arose in relation to all of this. They then they drew down a loan for this. Part of the reason why the bank wouldn't pay for this was because there was a solicitor's undertaking which was never actually put in place, to put security in place. So the bank were faced with suing a solicitor who happened to be one of the biggest branch customers of the particular branch which lent the money. So they didn't want to be suing one of their best customers. Also, there was another issue. You know, there's always an elephant in the corner of the room that nobody wanted to talk about. In this mediation, there was a herd of elephants they wanted to bring in, because it turned out there was a second drawdown. And the 4 brothers said, we knew nothing about the second drawdown. 2 brothers admitted that their signature was on the loan documentation for the second drawdown, and they said, we remember him coming in one day when we were in the middle of carving the stuff for the lunchtime, and he said, I'm off to the bank, I need you to sign that there. And we signed something, but you know, we're literally putting down the knife, signing, and he goes off. The other 2 said, at that stage, if he'd come near me with anything, I wouldn't have trusted it. I'd have taken out a microscope to read it first. So that's why only 2 brothers signed for the second loan. And even the 2 who had signed were pleading non-es factum. So the bank were looking at a large second loan, which potentially wasn't secured. The first one wasn't secured anyway, because the solicitor hadn't put the undertaking in place. Anyway, following day after the whole thing was over, bank manager rang me. And he said, can I ask you about what happened yesterday at the mediation? And I said, I'm sorry, I can't tell you, it's all confidential. He said, no, I've Brian, that was the younger brother, here, he's told me the deal was done, he's here looking for finance for the deal. I just want to ask you one question. He said, I'm sorry, I can't tell you. Brian shouldn't be telling you now either, because he signed up to confidentiality. I appreciate he's telling you there's a deal, and he has to tell you what the deal is to get the financing for it, but I can't tell you. He said, no, it's just one simple question. Did you use hypnosis, drugs, or a shotgun? Because there was no way I thought that was going to work out. And he said, look, just send in your bill, we'd be delighted to pay it, because they'd sorted out all their problems. Anyway, highly beneficial, and seemingly intractable disputes can be resolved with it. But the court's power up to the passing of the Mediation Act was limited to adjourning to facilitate people. Now, to a certain extent, that's still the situation, but there's the kick in the teeth of costs, and I'll keep coming back to that point. Kelly says as well, any element of compulsion isn't conducive to successful mediation. In other words, the courts won't force somebody who doesn't want to go to mediation to go out the door, walk around the block, pass the door marked mediation, and come back in the door marked litigation again. They're not going to force somebody to do it. They can still, however, say, you could have got what you've got by coming to court by mediating, so you mightn't get your costs. But you'll see that all depends on the circumstances. The courts don't want to add a further element of delay. Now that's particularly important outside Dublin. They don't get it in Dublin, because fine, an adjournment in Dublin might mean that they're kicked out of a list, but not for too long. They don't understand that when the High Court goes on circuit, it's 6 months before it comes back, and 6 months can be material delay for clients outside of Dublin. Court shouldn't make the countenance of an order where no realistic attempt is going to be made. This is one of my favourite slides for mediation. The reason being, are they about to chew each other's heads off at the start of a row, or are they about to have a tender moment at the end of a mediation? I did this in a 6-hour version in Maynooth for the Master's Programme in Maynooth in January. And I explained about how mediation works, and say, you know, I get everybody together at the start of the day for a meeting, and each side will kind of have an opening statement if they want, and explain what their position is. And after the group hug, we break up into separate rooms, and then I shuttle backwards and forward. There's an American on the course, and she came up to me at the coffee, and she said, can I ask you a question? I said, sure, yeah. You Irish are really friendly people, but how do the parties in conflict react when, at the start of the day, you ask them to hug each other? And I said, where did you get the idea that they hug each other? So you said that you have a group hug before you start, and before you break. I said, okay, colloquialism, I'll explain that when I go back in. And I had to, you know, explain about the use of language. Now, I've had a hug, curiously enough, at the end of a mediation, 2 health professionals who had a practice buyout row. They had worked together, one as an associate to the other, and they had a row, and then it was successfully mediated before Christmas. And they finished with a hug. The fact that there were 2 females is coincidental. Men only do the 5 seconds back slap, they don't do the hug. I even had a punch up at the start of a mediation once, top and bottom noise row in an apartment block. I was asked by the management company to mediate, and north side Dublin, certain socio-demographic grouping, no lawyers involved. And I was explaining the process, you know, and you listen very carefully and don't interrupt and take a note, and you have plenty of time to come back. And one guy thought the other guy was giving his wife the evil eye. So he hopped up, bop, and after I'd separated them, the explanation was, the man asked me to listen to what she was saying very carefully. And I wasn't even giving her the evil eye, I was listening very carefully to what she was saying. So when that was explained, there was a handshake then, because it was legitimate to bop the guy out if he was giving the wife the evil eye. Anyway, so unwilling parties, the courts won't force them to do it, won't add to costs. Greatest prospect of success when the issues are clear. Before you get into very expensive discovery, where that can be, the costs become an issue as well. I did a deputy dog training run in Reading in the UK on a large commercial mediation. It was a £6.5 million claim by a landlord that a tenant had vacated a large industrial premises, left it in blank order, hadn't kept it up to the required standards, and the landlord was claiming for putting it back in correct order. The defence was fraud. There was an accountant, a forensic accountant did it, no lawyer involved for the tenant. He was on his own, no clients with him, just him, and in fairness he did a brilliant job, because in England they have things called Scott schedules. I don't know if anybody here is familiar with Scott schedules. Very detailed claim in relation to all the building works that had been done, and there were ring binders upon ring binders of spreadsheets and figures, and he had gone through every single one of these and he demonstrated that the figures didn't add up. And he said the great thing about Excel spreadsheets is they do add up. When you change one figure, they add up. He said, what I speculate happened here is someone took an Excel spreadsheet, converted it to Word, changed the figures to massage a bigger claim, PDF'd it, and then sent it over. And he showed where all the figures didn't add up. So it was fraud, fraud, fraud. It settled within 5 hours for £630,000. £6.5 million to start, set for 630,000. The next 3.5 hours were spent arguing about the costs before we finally got out the door. Went to a restaurant and we had just ordered when in walked the accountant into the same restaurant. This was in Reading, in England. So Anthony Blasdale from Scotland was the name of the mediator, a very experienced guy, and he invited the guy over. And he said, look, you can join us, the other crowd come in. And so the guy joined us and he insisted on paying for the meal because he was on a success fee. He was on a percentage of what he saved. And you want to hazard a guess of the percentage he was on, given that he had knocked off 6 million off the claim. Quite brilliant. 10%. 10%. Any events on 10? 15. Any events on 15? 20%. He made $1 million. Now, there was months of work went into it, but it explained why he had the house in Florida, the house in Jersey, and the house in France, as well as his own house where he lived somewhere in the Cotswolds or somewhere nice in England. He did about 5 or 6 of these cases a year, he said. Nice work if you can get it. So, once the issues are clarified is the issue. Now, I had a case last year where somebody sent a letter of claim to my client and said, here's the letter of claim, we'll mediate. And I'm a great man for mediating. But my response was, you have no case in fact, you have no case in law, please go away. They then said, here are the proceedings, we're about to serve them, do you want to mediate? You have no case in fact, you have no case in law, please go away. They served the proceedings, and then they also served the statement of claim. Before we go to the trouble of instructing counsel to draft a defence of this, you have no case in fact, you have no case in law. I was getting into a sing-song at this stage. No. We served the defence, we then went to mediation, and our defence at mediation, so to speak, was, you have no case in fact, you have no case in law, please go away. The senior on the other side was Jim O'Callaghan, Fianna Fáil justice spokesman, etc. He came in and he said, just for tonight, we'll take 375 grand to go away. And I said, Jim, you have no case in fact, you have no case in law, and has your client given you the following? Da-dum, 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 da-dum. No. I said, go away, ask them about all this stuff. Goes away, comes back an hour later, and he says, just for tonight, 75 grand. Jim, you have no case in fact, you have no case in law. Go away. He comes back and he says, look, would you pay our costs? I said, no, go away, you have no case in fact, you have no case in law. They left my office, that was where we were having the mediation, in September. We haven't heard a thing from them since. So sometimes the answer is, even if you're mediating, is to take a choice of any two adjacent fingers on the one end, moving them up in one direction. It depends on the case. So, anyway, pre-action trials, under the Legal Services Regulation Act, This is coming. They're going to do it first with clinical negligence cases, the smear test cases, the medical negligence cases, where you've got all this disclosure beforehand. But like everything else, it'll creep into the High Court first, and then it'll start coming down to everything. Everything will have to be pleaded on paper. You'll have to have all your statements up front. It's going to become a paper game. A lot more work before you actually get into court in terms of litigation. All that is part of it. So it's literally, you're going to have to put all your cards on the table in advance. Now, big concern for lawyers is, does the ADR actually stand not for alternative dispute resolution, but alarming drop in revenues? When the Act came online, it was passed by the Oireachtas in October, the Law Society, the Chartered Institute and the Mediators organised a gig to promote the fact that it had actually been passed. There was a kind of a top table seminar up in Blackhall, and this question was asked: will it mean a drop in revenues? On the basis, if you don't have the big case, you don't go all the way to the High Court, you don't have 10-day trial, you don't end up with the big fees at the end of it, where are you supposed to go? Now, it's a different lecture. I'll give Matt the name if necessary as to call it. But the law society can show you that it's fallacious to think that if you get the big fee, you're actually making profits. The big fee cases, all they're actually doing is cross-subsidising the work you don't get paid properly for, or all the pro bono stuff. And if you could actually get paid for the hours you work properly, you'd be doing grand. And there's a question of getting the gratitude curve high. And if you can bill when clients don't mind paying, and it's going to become important, to explain why you should be getting your bills out and paid early in a minute, you can actually do much better. And I give an example of it. I did a thesis back in 1983, and it was an apprentice. I did another degree, and I did a thesis in limitation of liability under the Merchant Shipping Acts 1894 to 1981, a subject I know you deal with on a weekly basis up here, so I won't mention it anymore. But guy who was dealing, he was the CEO of a shipping company. He was dealing with one of the glass palace firms, as I call them, on the quays. And even though they were overlooking the quays and the docks, they couldn't answer his question about a cross-section between maritime law and insolvency. And his problem was that Qualsam, who were bathroom manufacturers in Wicklow, had gone into examinership. They were shipping a rather large consignment for Qualsam all the way from China. They were owed a large sum of money, and the examiner was saying, you cannot take any action against me, you must give me that very valuable cargo. And he said, we're going to lose an absolute fortune if we do this. He said, I went on to the usual people we deal with, I went on to the commercial department, and the commercial department can't answer my question. I went on to the maritime department, and the maritime department can't answer my question. He said, in desperation, I googled bankruptcy and maritime lawyer, and you're the only person who came up with the Google search. He said, can you help me? And I said, there's a very technical legal answer to the examiner's proposition. It starts with B, it ends with X, and there's two L's and two O's in between the two of them. I said, you have what's called a shipper's lien. It's like a solicitor's lien or a repairer's lien. And you don't have to take any action to enforce it. The examinership legislation prohibits you from taking action, but you don't take any action when you simply inform somebody that there's a lien. Result, they went into Frank Clark, who was in the High Court at the time, applied for a Section 10 cert, which is what they usually apply to pay the ASB. My client gets 175 grand, which is basically the core costs covered, client delighted. I explained how an examinership works. If the company is rescued, there'll be a dividend. 6 weeks later, dividend check, 10 grand into the office. Ring the client, I said, for some reason they've made the check payment to me, I'll run it through the books and send it out to you. What are you talking about? Explained again about how to be a dividend. I said, it represents a percentage of the balance of your debt that you didn't get when your actual core cost was covered. And he said, oh, I've ruled it off in here. He said, besides, your fees will be 10 grand anyway, wouldn't they? And I said, I don't know what you're getting charged by the Glass Palace firm, but my fees will be under 2 grand. He said, Bill, you keep the 10 grand, send me an invoice to match. Brilliant result. Thought we were, in the clappers, delighted. I have no problem with you keeping that. Now, I worked out about 2 grand an hour plus that. It never happened before. It hasn't happened since. It may never happen again, but it's an example of billing when the gratitude curve is high. And if you can get the reputation, whether it's Hearts or it's Holohan or whoever, that they're the people to go to who can solve the problem in 6 days, 6 weeks, or 6 months rather than 6 years, then you become what I call the popular man. In fairness, in the interest of equality, I tried to find an image for the popular woman as well. I have to tell you, I couldn't display what I found. But the point is, I got a phone call in the middle of April. It was a Friday at 9:30 in the morning. Could I act as a mediator on something? I said, yeah, I'm open to suggestion. We started it at 3:30 of the afternoon. On the following day, there was a barrister friend of mine getting married the following day on Saturday. This is in Dublin, and I texted the parties to explain that I've done the conflict check. Yeah, I can do the mediation, but I said there's a barrister friend of mine getting married tomorrow, and I'm going to that wedding one way or the other. And I was using Siri to dictate it on the phone, and I sent the text, and after I looked at it, I had to correct, because Siri, instead of saying I'm going to the wedding of a barrister friend of mine, typed I'm going to the wedding of a bastard friend of mine. But the solicitor on the other side sent back, is there a difference? But literally, if you can get the reputation of sorting problems out quickly through mediation, you can build handsomely. And that is going to be important, because under the Legal Services Regulation Act, and I'll come back to this, when it comes into force sometime next year, you're going to have to, when you give a bill to a client, say, here's my bill. You are entitled to have a row with me about the bill. And if you want, we'll get Bill Holohan to mediate and pay him a fee to sort it out. Believe it or not. So if you can actually give the bill to somebody when they think you're a baby Jesus, male or female, and they're willing to pay you, so much the better. There's no right time, no wrong time. All you got to do is think about doing it at some point. Again, premature wastes time. You must make sure you've got the issues clarified. That's usually when the pleadings are in. It may be, however, that correspondence has clarified everything and you know what it is. I've done mediations before proceedings issue, after proceedings have issued. I've done mediations in the middle of hearings even. Trick is to identify the happy medium. That's the 150-day case that I was talking about in front of Paul Gilligan. They were at hearing for 150 days before sense dawned and out they went. Now that said, some people insist on going to court. And I get to quote my mother every single day, sometimes more often than once. There is no point in somebody being stupid unless they're given a chance to show it. And we all have those clients, the people who insist on their day out. Now one of the beauties about mediation is that people come into mediation and it's not a very stressful process, but you often find people at the end of the day saying, Jesus, if this is what a friendly chat is like, I'd hate to think of what being cross-examined by a barrister is like, because as part of the process, you do reality testing and you do bubble bursting with people. And you kind of say, well, you know, have you thought about this, that, or the other? Now, it's not a cross-examination, it's just a reality check with people. And, you know, sometimes the scales fall from people's eyes and they realise, actually, things mightn't be as rosy as they think. And they equally get weary. The longest mediation I ever did started at 9 in the morning and finished at 4 the following morning. And that was fine for me, as I mentioned earlier, I only sleep about 4 hours a night. But at that stage, people were beginning to nod off. But getting to yes, why and how it works. Any of you ever read this book or seen it? I'd recommend it. Even if you never mediate, if you litigate and you negotiate, it's a very interesting read about, I'm very interested in what makes people tick and what makes people thick. And there's more than a hedge in the difference. And this will tell you a lot about it. But it's getting to, this is all about negotiating and getting to an agreement. But you have the example, the orange quarrel, right? So who would be the senior doyen of the solicitors down here? Give me a name.
John Lonigan. John Lonigan.
Okay, John. So John is wandering into the bar room and he finds two people. We'll say it's Fiona and Matt. Right? Now, there used to be provision of biscuits in the bar room, but the biscuits had only gone by 9:30, so they decided fruit, but that might last until lunchtime. The two of them go into the bar room at lunchtime, they're both starving because they haven't had anything to eat, and they both dive for the one remaining orange, and they both touch the orange at the same time. They both want it. What's the usual expected result in that scenario?
I get the orange.
You think he's chivalrous, is it? Well, most people would say the judgment is Solomon, and you get the 50-50, right? But each declares it. The issue is that she's actually a Dorina fan. All she wants is the skin, because she's going to put an orange zest on the cheesecake she's going to make tonight. Matt is a man. He prefers a steak, unless he's vegetarian. And what he wants to do is he wants to have a nice big steak, but there's no steak available in the bar room. He'll settle for the orange until he can get home and have a bite at home. So they each want something different, but they don't know that. They can each actually get 100% of what they want, but they don't know that. But in comes John, and John says, "Jeez, lads and lassies, what are you on about?" Up to now, they were about to split the orange down the middle and take 50-50 of what they don't want. 50-50 of what they do want, 50 what they don't. Remember I mentioned Humpty Dumpty on the wall earlier? The mediator, get to see both sides. So in comes John, takes Fiona aside, takes Matt aside, has a listen, finds out what's really going on, and comes up with the solution. Gets them to explain exactly what they want. Ta-da! Suddenly they can actually have 100%. Now, it's a simplistic example of a win-win, but it illustrates the point. Real cases are more complex, and if you're really interested in working out how you can try and improve the chances and do a win-win, there is a book on it, John Nash, A Beautiful Mind, if any of you ever saw the film. He did a PhD on the subject and about negotiating for maximum return. You can read it if you want to. Again, another great middle of the night book that I've read. You might want it for insomnia or whatever. But it's actually fascinating when you understand what makes people tick and how to influence people. And that includes your colleagues. Now, when I'm arbitrating, and I'm going to give Matt a job to get me another button down there, I explain that there are 4 versions of what happened. There's what the plaintiff says happened, there's what the defendant says happened, there's what might actually have happened, because people remember things differently and to their own advantage. And lastly, but most importantly, there's what the judge or the arbitrator decides happened. And the last one might not suit either side. Back to the lose-lose. Michael Howard, senior counsel, does he ever come down here? Right. Very good senior counsel, he's from Limerick. But he gave an example to a client in a consultation a couple of weeks back, and he said that he was a witness to a fatal accident right in front of him. Somebody was killed in a car crash right in front of him. Gave a statement to the guards, and the guards rang him back after about 4 days and said, "Could you ever come in to amend your statement?" And they said, "Why?" So just a couple of details. You got the colour and the make of the car wrong. Now this is a senior counsel who's well used to detail, and he said he couldn't believe that he got the make, and he looked at the car in the yard of the guard station. He said, "Yeah, that is the car I saw," but he had remembered it was a completely different make of car and a completely different colour. So, equally I say to people, let's not dwell on matters historical, lest they become matters hysterical. In other words, let's not do the inquest, look forward. Acknowledgements. You take the following scenario. Matt decides he's given up the solicitor again, becomes a counsel, rapidly elevated to senior counsel. He stands up on his first day as senior counsel and he says, "I'd like to say, Judge, my client wishes to apologise profusely to the other side and admit that they were in the wrong as to how they handled this." People will keel over in shock. Up pops the other side. "Judgment, please, in our favour. Order for costs." You can go into a mediation, because it's all confidential. You can start off and you can say, "John, Louise, Kate, Mick, Dan, whatever, I'm sorry, I called you a tumbling so-and-so, or whatever, I disrespected you, I shouldn't have, I don't agree with your position, but I owed you more respect. I handled it badly, whatever." Can't come back to bite you, because it's all confidential, but you take the heat out of it. Now, equally as a mediator, I've had instructions. You go tell those honkers in the other room, right, and what they say, well, they don't quite agree with your position, right, so you modulate the language to the maximum effect, but that's all part of it. And remember, 1 ear, or 1 mouth, 2 ears. Be reasonable, do it my way. Back to the 4 brothers in the pub. The older brother described the younger brother as a young pup, and they said at some point he's going to get up, he's going to throw a strop, and he will walk out in a tantrum. And the very first session I had with him, he threw down a piece of paper and said, "They're my demands, and unless they agree those, I'm out of here." I said, "Well, let's have a look at it, we'll discuss it." No, unless they sign those in the next 10 minutes, I'm out of here." I said, "Well, calm down, we'll have a talk about it." "No, you can ring them in the side and out the door." Now, the others had warned me that if he did something like that, and they showed me the summons, they said, "We're down the street after him to serve him. The mother's still alive, but we've had enough. We will take him on the way to the matter on this." So he's gone out the door. I'm thinking, "Oh, this forgiving cowboys, what do I do now?" So I rang him, and his name was Brian. I said, "Brian, have they signed?" I said, "No, they haven't." "Well, I'm not coming back to this sign." Click. Now they said, okay, they described him as a 15-year-old, and at the time I had a 15-year-old who who was a bit petulant. And I said, okay, I'll relate to him as I relate to my 15-year-old, even though this guy was 52. So I rang him again and said, Brian, what have I done to insult you? What do you mean? I said, well, obviously I must have insulted you. You got up and you walked out. I must have offended you in some way. No, they've insulted me. But did I insult you? No. I said, well, I'm feeling very upset here. You know, you've got up and walked out and we're trying to have a reasonable conversation with you. Oh, I'm sorry. Will I come back so? I said, if you would, that'd be great. So I had to negotiate between him and the process to get back in. Meanwhile, you know, the fellows keep the plates spinning on the stage. I had to go in and keep them spinning for a while before we got back in. But as I say, we successfully mediated. Now, I'm not going to bore you with this bit. You can read it in your own time about what the mediators do, how does it work, going back and forwards, getting people to think about it, challenge them, etc. I'm going to focus on the act and the thing. One point, however, is I say this to people who insist on being right. I say it's all very well being right. And I tell the story about the guy who's driving towards the traffic lights. He has the green light and he can see a truck coming down the hill which is weaving on the wrong side of the road, in and out, taking out lampposts, lights flashing, horn blaring, obviously out of control. But he has the green light. So as far as he's concerned, he can drive through the junction. So that's what they put on the tombstone. He was right, dead right as he drove along, and the fellow who killed him was dead, dead wrong. Be reasonable. You've got to understand as well what motivates people. You know, what's really making them tick. Back to the two brothers running the company. Who'd have thought, in the context of a petition to wind up a company, that the motivation behind it was the desire to have a child? Right? It doesn't feature. You won't get that coming out in the round of the round hall. But once you get into the rounds of mediation, you get to understand it. That's roughly how mediation works. Anybody here been through mediation? No? Basically, the way the day works is you prepare for it, you set out the ground rules, you explain the process, you get people to tell their story. And sometimes people talk about wanting their day out. But it's a question of being heard. And part of the whole thing is getting someone to understand where the other side are coming from. And accepting their position. Not saying, I yield to your position, but understanding it. Stephen Covey, The 7 Habits of Successful People. Anyone read it? As if I'm actually hearing about it? He tells a great story about it's called changing the paradigm and changing the perspective with the benefit of full information. And he gives an example of a guy who gets on a commuter train with 2 kids. And as far as the rest of the commuters are concerned, they've been fed a diet of Smarties and Coke because they start bouncing off the walls and the man is looking at his shoes. And eventually somebody snaps and says, for God's sake, would you ever control your kids? They're running wild. And the guy looks up and says, I'm sorry, I don't know how to tell them their mother's dying. And suddenly, in the book, out come pens and paper. Nowadays, the iPads and iPhones to amuse the kids. But with better understanding, better information, more facts, you get the broader picture. I was only looking at the weekend, you can Google it on YouTube if you want, a 1984 ad for the Observer newspaper. And it talks about getting full information. And it shows a skinhead walking along the street. And suddenly he starts running towards this guy with a briefcase. And it looks as if he's going to mug him, right? But then the camera draws back, and you see actually there are bricks falling from a platform up above. He's actually saving him, he's not about to mug him. So, once you have the full information, you get a different picture. But it's storytelling, clarifying and reframing, which is kind of getting people to understand the thing, considering options, and again, back to the 2 brothers, they sold some assets to generate a pot, all of which went to the older brother, so they could set up the business in the States, even though part of it was due to the older brother. Agreeing on the options, an agreement, and out the door. Now, mediation, representation, or advocacy is completely different. If you're going into court, and you're all well used to it, I'm sure, from the district court, you're arguing cases, it's a case of accentuate the positive, eliminate the negative, and don't mess with Mr. in between in terms of your client's case. Brian McMahon, retired High Court judge, gave a talk at a Chartered Institute lunch a couple of years ago about advocacy. And he said, you listen to the counsel for the plaintiff, he's a good Kerry Bloss. And he says, and you think, my God, she's right. And then you listen to the counsel for the defendant, and you think, my God, he's right. He says, it's very important at that point in time now to think about the little voice in the back of your head saying, would you ever cap yourself on, we can't both be right. Mediation advocacy is very different, because you're not trying to persuade the person in the middle, mediator, of anything. You're trying to persuade the other side. And the trick in an opening statement, for example, at a preliminary meeting, the group hug, as I called it earlier, is to have the other side thinking, well, actually, maybe they have a couple of good points when they break from the opening session. And if you're really interested, the Chartered Institute will be running a training course on mediation advocacy in July. I'll send you information about it. But it's all about persuading the other side that you're right, not about persuading the person in the middle. Again, beware of what lies underneath. Lawyers' involvement, pre-mediation, giving advice. At the mediation, it's advising people. And as a mediator, you try and deal directly with the parties rather than representatives. Now, sometimes you need to talk to the lawyers, not the actual parties. It depends. But the role of mediation is to say, if somebody's considering doing a deal, listen, you're about to jump into a hole 6 feet wide, 6 feet deep, and 6 feet long. And there's concrete going on top of you when it's all over. Do you understand the deal you're about to do? If people say yes, they'll be suitably advised. And then post-mediation, if it comes out of court, and I'll explain this under the rules in a minute, if it comes out of court and it's gone back to court, you go back and you arrange for appropriate rulings in relation to it. The lawyer's involvement, this is an extract from the Gazette. It's from 2 different Gazettes. I liked the Batman logo a bit. That's from last month's Gazette. This bit is from this month's Gazette. But it's just another way of getting the job done for the client. And that's Michael Quinlan. He wrote in this month's Gazette about mediation and the benefits of it. And you now have a statutory obligation to advise about the advantages, the benefits of mediation, the cost savings. That's because they're there. But up to now, lawyers haven't understood it. Again, you can do it. That's Minister Madigan, herself a solicitor and an accredited mediator. She spoke at the Chartered Institute lunch about the benefits to it. Again, you can go through it. How it works, as I say, opening session together, shuttle backwards and forwards, you get a patchwork quilt. Part of the thing is to try and influence people into thinking that they're the first to move. So, what would you be prepared to give if I can get them to agree something or other? And you say, okay, I'll give such and such. Ditto on the other side. And then you kind of make each side think that they were the first to move, so they feel great. And you have the first bit of the patchwork quilt. Then you move on to the next bit. Now, I had one mediation where there were 6 issues between them. We got 5 of them resolved. But that meant the only thing that was left was one issue. They agreed to continue to litigate the one issue, and in fact, they settled that 3 weeks later because it was unimportant in the greater scheme of things. So, you go backwards and forwards. What's been happening? I'll very quickly run through this, but again, you can study this in your own time. We're very good in Ireland at putting sticker plasters on things. We never stand back like Jaws and say we're going to need a bigger boat. Right? We never stand back and redesign things. We always do a patchwork quilt job or a patch, stick a bit of tar on the cork, or we put a sticking plaster over the leaky hole to try and patch up something. So the whole thing's been a patchy spot bit of mediation every now and again. We have various court rules, we know the Act, we have various court initiatives. In Dublin, for example, if you want to issue a barring summons or maintenance or whatever, they say, do you want to go upstairs? We have mediators upstairs, we'll help you sort out the problem. And over 60% of cases are resolved through mediation in Dublin, no, not in court. Various other rules and rules of practice. There's an EU directive which kicked the whole thing off. We had the 2004 Act, which allowed for mediation and inspected personal injuries, not really used. Family law is the main area in which you had it, and people had an obligation to do it. Employment law, very common. Now the Act it doesn't apply to workplace mediation, but that doesn't mean there's not a lot of workplace mediation going on. I'll explain how that works. Equality law, insurance law as well. The pensions and insurance ombudsman, they're merged since the 1st of January. They started off mediating 4 years ago, and they did 15 cases in the first year. Anyone want to hazard a guess as to how many they did last year? How many insurance disputes were resolved by mediation last year? Wild guess. Over 3,800, which would otherwise possibly have ended up in litigation. Landlord and tenant. I sat for 6 years on the Residential Tenancies Tribunal, and now in the main it was adjudication rather than mediation. I only ever did one mediation because the relationship is over. Landlord wants to keep money, tenant wants money back. There's no common future, so they don't see a benefit in mediating. They'll just have the run. In fact, the most interesting case I ever did was went to Galway for a tribunal hearing. I was a member of the Disputes Resolution Committee, the top thing. And there was a 3-person tribunal. Went to the G Hotel in Galway, checking at the desk, where's the tribunal room? And I heard, are you the tribunal people? And I turned around, there was a guard in riot gear with a helmet. And I said, yeah. And he says, oh, myself and the lads are here for you. I turned around, there's 2 more of them in riot gear. I said, What do you mean you're here for us? He said, has no one told you about the tenant? No. He said, oh, the super thought it would be best if we came along. So it was very reassuring. This was 20 minutes before the hearing time. As we went in, 20 minutes before the hearing time, they put on the helmets, they strapped them up and they took out the batons. And they stood for the entire hearing between us and the tenant, who had mental health issues. Now, he actually won the case because he had been unlawfully evicted because of his mental health issues and being an utter looper. But that didn't stop him rearing up at us every now and again. Every time he did, the boys stepped forward and he'd sit down and they'd step back. It's interesting work. Debt collection, after the Monaghan case in 2009, they introduced a system where you can mediate debt collection. The only issue is who's going to mediate a €1,000 claim in the district court for a tenner a week. It's not going to happen. I actually suggested to Rosemary Horgan that they should try and get the retired district judges who don't understand the whole thing to do it pro bono. But the court service and the Department of Finance haven't been able to sort that out in terms of providing facilities, money, budgets, insurance, you name it, training. Commercial court, that's where it started. Peter Kelly went off and came up with the rules. Problem was they started off in the commercial court only, which is $1 million plus, not on the High Court, and it was only on the basis that somebody asked, can we go out and mediate? Yeah, knock yourselves out, we'll give you all the time you want. A judge couldn't suggest it. And that, I remember Sean Fawcett, when I qualified in 1983 in Cork, would always go, do you want to take some time outside the door? And they could always do that, but they couldn't actually direct people to mediate. The 2004 Act, on the request of a party, they could give you time. And the chairperson had to be a solicitor or a barrister. All notes were confidential. Costs had to be paid equally. Shortcoming, only personal injuries cases, not all circuit court cases. So for your boundary row, your 117s, whatever, it didn't apply to it. District Court, I've already mentioned that. Circuit Court case progression, we tried to persuade the judges to do that, but they said it only applies in case progression hearings. Then you had the High Court rules, they could invite, but they couldn't, there was no bite. They could invite, but there was no bite. There were no sanctions for not engaging or making their life easier. Cross-border directives, they had the opportunity to make that applicable to all internal stuff. So if you order CDs from Slough, in the days when you ordered CDs from Slough, it was all online now, or downloads, this would apply, and you could mediate cross-border disputes. They could have done it if you were ordering them from Sligo instead of Slough, but they didn't apply it. So they missed out on an opportunity in relation to that. Again, statute of limitations, basically if you take time out to mediate, the clock stops on the statute. Back to one of the earlier slides, the professional negligence book that I wrote, my advice as a professional negligence lawyer is do not rely on the statute to get you out. It's a bit like the PIAB extension of time on the statute. You shouldn't be relying on it. Issue the proceedings, keep them in the drawer, hope you've never got to use them, but don't let the clock run out. Because you're all familiar with Murphy's Law. Anything can go wrong, it will. But are you familiar with Trude's commentary on Murphy's Law? Murphy was a bloody optimist. If you think back to the snow, I know of somebody who rang my office to know could we help them in getting proceedings issued on one of the days of the snow, because they couldn't physically get out to the court office to do it. They were snowbound. And it was literally the last day. And we were able to walk to the court to issue the proceedings for them, because they physically couldn't get out. The last thing they expected was to be caught by the snow on the day. So, get it out there. The MUDS Act. Anyone done a MUDS Act claim? Multi-user development? This is where you've got a multi-tenanted building. If you're going to go for proceedings under Section 24, you must try mediation first. If you go to mediation, the crucial point under the MUDS Act mediation is the mediator gives a very comprehensive report and can say, he played silly buggers. She was fine, but he was messing about. He came in, he didn't engage properly, he was going through a box-ticking exercise just so that he could say he went to mediation. It breaches, in one sense, the confidentiality wall of mediation, and it's only under the MUDS Act. Under the Mediation Act, it's a very anodyne report, as you'll see. So, that brings us up nearly to date. We then have the Personal Insolvency Act. John Lynch, solicitor, who's also a PIP, who was trying to ring me earlier. He's one of a handful of solicitor PIPs. One of those solicitor PIPs was consulted by a couple who could not understand why he could not take out his Harry Potter wand, wave it and make all their debts disappear, allowing them to keep the family home and the buy-to-lets. And they were so dissatisfied, they went to the Insolvency Service the following day to make a complaint about it. And the complaint ended up being mediated under the Personal Insolvency Act. The Legal Services Regulation Act. Up to now, anybody who has a complaint made to the Law Society about them, the Law Society played tennis with the complaint. They'll bat it onto you, you answer back, they'll bat it back to the client bats it back to them, they bat it back to you, and this goes on until somebody gets tired and there's some kind of a resolution achieved. But they don't actually mediate as such. The Legal Services Regulation, a regulatory authority, when they come online, they're going to mediate stuff. And I already mentioned about section 152, when you deliver your bill, you're going to have to inform the client that they're entitled to have a row with you and that they're right to mediate about it. So the idea is you don't get them when they're likely to have a row and want to mediate. Get them while they're willing to pay it and pay it handsomely. Or ideally up front. I had an inspection when I set up my own practice 20 years ago. I broke from a larger firm in Cork and I set up on my own. And you're guaranteed within 2 years to have an inspection. So if you want to, if they haven't been down to you, they're coming, right? And in fact, you should invite it now, because Eddie Sheehan, who's the accountant for this area, he's retiring, and Eddie's grand. But I can tell you, the guy they're bringing afterwards is a nightmare. So ask a volunteer for it if you haven't done it already. And Eddie came in and he did the inspection, and they sit down and they go through the report with you, and they explain what they're going to report back. And he said, I have to tell you now, there was something very suspicious here. I said, what? And he said, every file I asked to see, there was a section 68 letter on it. I said, what was suspicious about that? And he says, half the practices I go into, they don't, this is 20 years ago, or 18 years ago. He said, half the practices I go into, they don't have them at all. The other half are hit and miss. And he said, I could not believe that it was on every file. So I stopped asking, and this was before we had electronic filing with physical cabinets. He said, I started going through the cabinets, and it's on every file. And I said, but you're supposed to have it on every file. And he said, would you ever tell your colleagues that? He said, why do you have it on every file? I said, 2 reasons. I said, one, you're supposed to have it, and secondly, if you're going to have a row with somebody about the fees, it's a lot better to have it before you do the work you're not going to get paid for, rather than, you know, doing a lot of work and then not getting paid for it. And he says, well, my experience is most people think you're fighting the client off and you actually tell them how much it's going to cost. And I said, but fine, if they can't afford it and they go away, then I'll actually get paid for what I'm doing. And he says, that's very logical. He said, do you ever have a talk with your colleagues about it? Anyway, the Legal Services Regulatory Authority are going to mediate all of these things, and you have to end up paying for the mediation. So you don't want to be there. I don't mind mediating disputes for colleagues, but I have to make a living too. So we're on to the meat of the evening. The Mediation Act. I know you're all very familiar with legislative process, and as you know, when the courier leaves Kildare Street, the Oireachtas have actually passed it off on the final vote. It goes out by courier, literally, motorbike courier, out to the park. There's an army motorcycle rider takes it out. And the President must sign it within how many days? Well done, 5, right? The President must sign it within 5 days. So I knew it had left Kildare Street and was going out. And you know the way Donald Trump has a big signing ceremony in front of the cameras, and if it's anything to do with the NRA or gun control or Muslims, the pen becomes a treasured object. It's not that I wanted the pen. I got onto the office of the President and said, look, my head is so big, I have 3 hats. I'm chairman of the Chartered Institute of Arbitrators, member of the ADR Committee of the Law Society, Mediators Institute, historic mode. Can I come and watch the President sign the bill into an act? I paraphrased, but the response was, Jesus, no one has ever asked something like that before. And the response came back, I got a very nice note signed by somebody in the park, which will probably end up in Adams in about auctioneers when I'm dead. But saying, sorry, unprecedented, never heard of, no protocol, don't know what the story is, maybe sometime, but not now. But consolation prize, I got a text at 6:10 on the 2nd of October last year to say, the President signed it 5 minutes ago. So I have the joy of getting the first tweet out. They can put that on my tombstone, big deal. Anyway, the Act breaks down into these: preliminary general, mediation general, obligations to solicitors, and that's the important bit, role of the court, and that's important, the costs, information sessions, and other acts. Definitions, section 2, standard. Mediation is a confidential, voluntary process where, with the assistance of a mediator, people arrive at a mutually acceptable solution. It's not an adjudicative process, it's not a determinative process, it's not arbitration, it's not adjudication. It is mediation, where you try and facilitate a discussion, a controlled discussion between people to identify and arrive at a solution that they're all happy with. Now, it involves compromise usually on both sides, but the psychology of it is that if you're going to negotiate, as part of the health episode I had 2 years ago, I was tested for everything under the sun. And I thought I had a very healthy diet. I'd start off in the morning with 2 yogurts, and at lunch I used to always have a pint of milk. And I did that for years. It turns out that I'm lactose intolerant, which explains why there were a lot of things behind me in my past. And put it as delicately as possible in that way. So I no longer take milk. I no longer take yogurts. I love ice cream. I really love ice cream, but I'm intolerant to ice cream. Now, if I had to give up a bucket of ice cream as part of my deal for whatever I'm negotiating, it would be a negative process. I resent, subconsciously or unconsciously, having to give up a bucket of ice cream. It's the same with clients when they go in to negotiate and to give something up. But if in mediation you start with what's the minimum you need to come out with? Tell me what you can live with as a bare survival. Don't give me your wish list. Your wish list might be 20 pages long. Give me your needs list, what you actually need to come out with. And then you try and improve on that. Consciously or unconsciously, it's a psychologically positive process, and people buy into it. And they feel better coming out of a mediation than coming out of a straightforward negotiation. Because straightforward negotiations, they're giving up. In mediation, if you start with the needs, you're actually gaining. Again, back to the books I mentioned earlier, the psychology. Mediator, person appointed under an agreement, has to be in writing, to assist the parties to reach a mutually acceptable solution. And they're the attributes of mediator, one of them being a big bladder, because you're running backwards and forwards between them unless you take toilet breaks. The Act doesn't define what it applies to. It defines what it doesn't apply to, so by inference it applies to everything that it doesn't apply to. Okay? Great logic. It doesn't set out any training or accreditation standards. In the same way that up to 10 years ago, whenever it was, anybody could call themselves an architect, or anybody still can call themselves an accountant. Anybody can call themselves a mediator. The question is, are you accredited by somebody? And the good news is, Matt will send you out the CPD certs for today, but you're all going home, except those who just left a minute ago, as accredited mediators, because I'm now accrediting you all as mediators. What's the value of that? Bugger all. If you claim to be an accredited mediator in the morning, and you say, Bill Holohan accredited me one Wednesday evening, A, who, and B, how long were you going through training, etc. There are bodies out there who do recognise standards of accreditation. It's going to come that it will be standardised, and I'll explain about that in a minute. It doesn't give any group a particular role. It was originally thought that the Mediators Institute was going to become the kind of the regulatory body, the registrar, etc. A bit like the Law Society, Trade Union and Regulator. The Mediators Institute said, thanks very much, we want to stay as the trade union, not the regulator. There's talk at the moment within the department that what they'll do is they'll define mediation as the provision of legal services. And they'll bring it in under the legal services regulator. It doesn't put any funding towards it. Age-old story, Department of Finance, tight purse strings. There is a mediation council provided for, but who's going to pay for the hotel room that they all meet in, the sandwiches they eat, the tea, the coffee, secretariat, premises, da-da-da-da. So the easy solution would probably be that they'll put it under the legal services regulator. That's the breakdown of the Act again. The original wording of the bill talked about civil proceedings, about the mediation of civil proceedings. In other words, it had to be at the stage of proceedings before you'd mediate. That was changed to any dispute. So you can mediate even if there are no court proceedings in place. The exclusions, workplace relations, anything that's capable of going to the workplace relations. Now, it doesn't mean that you can't mediate workplace disputes, it's just the Act doesn't apply to it. Right? Equally, the revenue. We all know the revenue don't negotiate. The revenue arrive at a position where they are happy or satisfied with a position that they have adopted as a result of a process of discussion and engagement, but they don't negotiate. Equally, they won't arbitrate, they won't mediate. They will cogitate, they will defecate on your client, but they won't mediate. Arbitration Act, obviously, because arbitration is an adjudicative process, it's a determinative process, it's provided for under separate legislation, similarly with adjudication under the Construction Acts. Domestic violence, childcare, there's protection for vulnerable people, vulnerable adults and children. So you can't arrive at a mediated solution without the approval of the court. It's a bit like family law, where the court has to be satisfied that adequate provision is being made for spouses and children, the same as a result of any mediation. Section 6 sets out it's a voluntary process, in and out at any time, assisted by a partner of your choice, and legal or other advice. I have had cases where it's all about numbers, it's about money, no real legal issues involved, and accountants actually came to the mediation. Lawyers were consulted for the agreement. At the end, they parachuted in for the purpose of drawing up an actual settlement agreement, but they weren't there all day. It was the accountants who were there all day. agreements to mediate, it must be in writing. Now, I have a Dropbox folder that I'll share with you, and it has more information, as I've said, than you ever wanted to know. It's got videos in there, the whole lot. I'll even upload this video afterwards in case any of you fell asleep or closed your eyes and you missed looking at me for the entire 2.5 hours. You can look at all of this. There's a template agreement to mediate in there. It's about 13 pages and it covers everything that you must, under the Act, put in there. Okay? It sets down how the mediation is to be conducted, the fees and costs, and the starting point is it's divided equally. I've had cases where someone has suggested that one side is willing to pay the costs of the mediation, and unless it's a clear case, I went down at a gig in Horse and Jockey in the early days of the tour. It was about session number 4 or 5, I think, and arising out of that, I was asked to mediate a dispute against the state, Ireland Attorney General, Uncle Tom Cobley and all, and the state said they'd pay the fees. Now, I make the point when I'm mediating, I prefer that it's split equally in case there's any suggestion when I'm bursting bubbles in one side or doing reality testing or saying, you know, are you sure, have you thought this one through, etc. Are you only saying that because the other side are paying you? I don't want that situation. Whereas if each side are paying me equally, it overcomes the problem. In one case I was fairly satisfied, in fact, that one side sent half the fee to the other side to send it to me to preserve the pretense that I was getting it. I suspected, but I didn't know, so I was alright. It sets out the time and place of the mediation. The mediation agreement must state it's to be conducted in a confidential manner and must state the right to take legal advice. So at any time before the final deal is done, parties have the right to take legal advice in relation to it. And I had a mediation in January where the parties came without legal representatives and wanted to sign up an agreement without legal representation. And I said, what I'm going to do now, I'm going to take a break for half an hour. I'm going to go down and get a cup of tea. It was in a hotel. I'm going to go and get a cup of tea. It's up to you whether you take legal advice or not, but I think you really should. And they did, and it led to another hour of negotiations, but that was because I could see the potential for the thing to fall out. And we've all had it where the phone call comes the morning after. Oh no, I went home now and I thought about it, and I'm not happy with the deal we worked out last night at all. They don't tell you, I went home and I got the head taken off of me for having agreed what I agreed, but that's the reality of it. So you need all the decision makers in the room. So, if it's going to be terminated, you have to terminate it. Back to the Scouts and the merit badges. Under Section 8, Mediator has certain obligations. You must establish impartiality. Before Christmas, I mediated between 2 dentists. This was the practice pilot, actually, that I mentioned earlier, where an associate bought out a practice principal. And it was 2 health professionals that contacted their professional body on the same day looking for help before they started litigation. And the person, they both contacted the same person who dealt with membership, and the person said, look, I think you should mediate, and I can suggest something to you. They suggested me. I got the names and addresses of the parties, and I said, stop the lights. The second person, if they lived in Fairgrove Gardens, Bishopstown, Cork, in the 1970s, before moving to Galway, because that's where the person was from now, they were a next door neighbour of mine until they were about 13 years of age. And given that connection, it might be better if we got somebody else. The other person was so impressed that I had disclosed this 40-year-old non-connection that they said, oh no, quite happy, and mediated. It was they both came with their spouses on the day, no lawyers involved. And curiously enough, back to what makes people tick and what makes people tick. Quick war story. The way dentists work is they have a separate room. They have a chair, a dentist's chair, and what they do is they hire out the hall. The associate, as they call it, pays the practice principal for the use of the chair, the use of the reception, the provision of booking services, etc., from the practice nurses and or the reception. And it's usually a percentage, half of the patient income. So whatever fees the dentist gets, half of it will go for the hire of the hall, so to speak. The associate bought out the principal, paid handsomely for the premises, paid handsomely for the practice. For some reason, didn't need to go there. The conveyancing took 2 years. Obviously there was some title issue or reservation or something. The week after the sale closed, even though they had done the deal and were operating now with the former associate being the practice principal for 2 years, it wasn't until the conveyancing was closed that the new principal terminated the arrangement with the old principal. There was a restraint of trade clause, and the old principal said, am I now to be denied the right to practice in the county Galway town that I've lived and worked in for the past 35 years? Well, duh, yeah, that's in the agreement you signed, and you got paid handsomely for it, was the answer. Both, as I say, about on the point of litigation, contacted the Dental Association, who contacted me, I stepped in, mediated. And what makes people tick? Timing. The notice of termination was served the week after the sale was closed, but 3 weeks after the former principal's mother had died. And what I got her to understand when I was talking to her, she was actually the former neighbour. When I got talking to her, because I remembered her mother, it was just unique circumstances, so I was able to talk to her about her mother, not as if her mother was a stranger. And I got her to understand she was actually grieving for her mother, because she'd been paid handsomely for the premises, she'd been paid handsomely for the practice. I said, why did you sell out? And she said, I have 2 grandchildren who were born 2 years ago when we did the deal. I want to spend time with my grandchildren and ride horses, because she had horses. And I said, so why are you so hung up on wanting to practice? If you agreed it, you were paid not to, why? And actually it came out, she actually understood she wasn't coping with the grief for her mother, and she had invested all of the energy, rather than deal with the grief for her mother, she invested all the energy in having the row with the former associate turned principal. And when she realised that, huge tears, but the whole thing stopped. And she said, I don't actually want to practice anyway. But she was having a row about something she didn't want to have a row about in the first place. But she didn't understand that. The practically new person said, I'm not bothered. She's been winding down for 10 years. So even if she set up in the morning, family and friends might go to her, but that'll be about it. I'm not worried. She can set up in the morning if she wants to. And they actually had a hug at the end of it. Now, unusual circumstances, but anyway, sorry, we must establish your partiality. You must give details, your qualifications, your training, your expertise, your experience, the types of things you've done. That's us people can shop around. Now, I happen to have 3 badges, so to speak. Other people have 1. I've also got a master's from Northumberland University last month, so I'm now officially a master of one trade instead of being a jack of all of them. That's back to the trophy wall I mentioned earlier. The Act. There is a provision under the Act that a mediator can become a conciliator. Now this is very important in the sense that you may make proposals if you're requested by the parties to do it. In other words, you bring the mediation, it's got a logjam. Now we've all had the scenario where you're 500 quid apart and you'd say, for God's sake, I'll pay the 500 myself out of the fee if we can close the deal, particularly if it's coming up to October and you have to pay the tax bill. As a mediator, you can't say for God's sake or whatever, but you try and get people to move and make the jump. But it may be that there's a blindingly obvious solution that you can't get the parties to think of, despite hinting at them or prompting them or even suggesting it to them. But if the parties ask you to, you can bring the mediation to a close and become a conciliator. Now, a conciliator is different. A mediator doesn't make proposals, doesn't make suggestions for compromise. You try to help the parties think of these things, but you don't actually suggest it. You bring the thing to a close, you formally sign off on it, we've now ended the mediation, I'm now becoming a conciliator. Here's what I think you should do. The difficulty is, the minute you do that, as a mediator, you step outside of the mediation process, you're no longer covered by the confidentiality. So if it doesn't work out, they're free to go into court and say, but the mediation ended, and John, when he was trying to mediate the orange quarrel, he said, I can become a conciliator. He made a suggestion, and you can refer to that because it's no longer covered by confidentiality. That's very important. You must make every attempt to minimise costs. I had a case where there was a contractual obligation to mediate for a minimum of 8 hours, and parties went straight to court. We went into Peter Kelly and said, stop the lights, a bit like arbitration, where if you agree to arbitration, you must go to arbitration. We said they contractually agreed to go to mediation for a minimum of 8 hours. Please send them out for the 8 hours. They arrived into mediation, they took off the watch, put it down, crossed the arms, and proceeded to sulk for 2 hours. Now there's a very experienced mediator doing the mediating, and he tried his damnedest to get them to open up. But after 2 hours he said, I'm ending this, and my report to the court will indicate that I terminated the mediation after 2 hours because there was no use of the purpose to be served by continuing. Now, he wasn't entitled as I say, to do a Muds Act and say he crossed the arms, sold it for 2 hours, he was playing silly buggers. But joined the dots, Mr. Justice Kelly. We were the people who came in and said we want to mediate. We were prepared to stay for 8 hours. The mediator shut it down. Equally, he got paid his fees up front for a day. And in fairness to him, he said in a letter the following day, I was back in my office by 11 o'clock, having started at, well, half 11, having started at 9, and he returned half the fees. Didn't have to, because it was a pre-Mediation Act thing, but it was actually very reasonable of him to do it. Gave reason to encourage using it again. Anyway, if you're going to withdraw as a mediator, you must give reasons for the withdrawal. You can't make the outcome contingent on, or fees contingent on the outcome. I've had that. We're trying to like you know to mediate, but don't like if you can deliver a result. It's only if there's a settlement now like we pay you. No, it doesn't work like that. You get paid up front, you get paid regardless of whether it's going to result in an outcome or not. And you have to try and manage conflicts of interest. You've also, as I mentioned, got to manage real conflict, as in the punch-up at the start of the noise transference dispute between the top and bottom apartments. That is where somebody had installed in an apartment a wooden floor and then got the 2-year-old to ride the bike backwards and forwards across. Of course, underneath there was like a drum, and that was what caused the rows. Costs to be shared equally unless otherwise provided for in the agreement to mediate. Now, the terminology in the Act is a bit confusing because you've got agreements going in and you've got agreements coming out. The agreement to mediate is agreeing to mediate. It's a bit like an arbitration agreement going in. What you come out with is a settlement, and it's a settlement agreement. It's like a straightforward settlement if you sign it up in the courthouse, but it can be very confusing. So you need to be clear about what agreements you're referring to. There's a difference between an agreement to mediate and a mediation agreement as in settlement. Codes of practice. The department are looking at this. They've invited submissions in relation to it to deal with CPD setting standards for accreditation. In other words, like the architects now, you can only call yourself an architect if you have certain qualifications. They're going to introduce the thing that you have to have certain qualifications, minimum of 40 hours training, etc. This kind of stuff. Setting ethical standards, complaints procedures, dealing with redress procedures. If somebody has no training, sets themselves up, causes chaos in a mediation, and you want to complain them, they'll have a system set up for that. Confidentiality is under Section 10. All communications leading to, during, and coming out of the mediation, they're all confidential, unless there are certain exceptions where there's a threat to persons, violence, risk of vulnerable adults, children, etc. Then you can breach the confidentiality. As a mediator, you have no privilege. Lawyers have privilege with their clients, but you have no privilege as a mediator with the parties or their lawyers. Now, standard practice, and you'll see it in the precedent that I provide, I get everybody in the room on the day, whether it's the supporters club, spouses, Lachimos, also ran, lawyers, everybody signs the agreement. And I had one solicitor from one of the Glass Palace firms recently. It was a large multinational company going after a small trader in Ireland over, among other things, trademark issues, and they agreed to mediate it. And the lawyer from the Glass Palace firm took great offence at the idea that they'd be required to sign the confidentiality agreement, the mediation agreement. And I said, look, I can see who your senior counsel is. Talk to the senior. Your senior will be well used to this. It's par for the course. And I explained that you can walk out, you have a duty of confidentiality to your client, but unless you sign up a duty of confidentiality to me, apart from Section 10 obligations now since the 1st of January, you could walk out and go to the newspapers about this if you wanted to. The client mightn't want it, but so that's where you have to sign up, and that's where it's important. Enforceability agreements. You have the hug at the end, two parties or a group hug, you've decided that you have a deal. The deal can be a legally binding contract in the same way as you have been used to up to now in terms of settlements in the courthouse, or it can be a gentleman's or gentlewoman's agreement. You can have part and part. You decide among yourselves. The default position is that it's a legally enforceable agreement, but you can decide it's not to be legally enforceable, if that's what you agree. Unusual provision, there are reasons behind it, but I won't bore you on that tonight. There's provision for the Mediation Council, which will be a body to promote awareness of it, develop codes and standards, etc. Again, it's unlikely, in fact, now that the Mediation Council will actually be established. and promoted. There may be an advisory board type of thing, but it's probably going to be subsumed into the Legal Services Regulatory Authority to promote it. We'll have to wait and see. Your obligations as a practicing solicitor. You must, Section 14 solicitors, Section 15 barristers. The reason why barristers have their own separate section is because barristers have direct access. And if they're advising a client on direct access, they must do exactly what you do. If they're advising you as the solicitor for the client, they must equally advise you when they're writing back to you in relation to it. You must write to the client to advise in writing about the option to consider mediation. You must provide the client with information. Now the pack I'll give you, will give you all the information you want, except it only gives my name and address. I'll give you a brochure as well for a group in Cork, Commercial Mediators group, which gives the names and addresses of others. But unfortunately, the Act says you must provide names, plural, and addresses, plural. You can do that by giving them the brochure, but say, look, forget the rest of them. It's the formerly foxy fellow you really want to use in this. Right? And you can tick the box with all the information that I'll give you. And that's your obligation done. You must, however, advise the client in relation to the particular circumstances of their case. And say the reason why you should consider mediation is because it could be a family row, it's your brother, you might hate him now, but for the sake of the mother or whatever. It could be the costs, but you have to set out the reasons why you're advising in particular. You must explain about the advantages, you must explain about the benefits. So the Act recognises that there are benefits and advantages. Again, the information pack they'll give you has it all in it. You must then swear a statutory declaration that you've done it. Now, when the heads of the bill came out in 2012, they invited all the mediation groups, except the Law Society and the Bar Council, in to make submissions. Every delegation was staffed by lawyers. I was there on behalf of the Chartered Institute, and I said it should not be the solicitor. It should be the client who should be required to say, yes, John, Louise, Mick, Pat, whoever has advised me, but I'm not going there, here's the reasons why. And that should then feed into the question of costs afterwards. And the reasons why they refused to go to mediation should influence the judge when it came to costs. But they didn't take that one up. They're putting it back on us. That's why it's important. You advise the client in writing, and equally, you get the client to sign off an acknowledgement. Just do up a simple acknowledgement. Yes, I acknowledge you've given me the following information, boom, 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 the Holohan's pack, whatever it is, something you've copied from the World Wide Web, whatever you're going to give them. I've decided I want to go to court, and I'm instructing you to go ahead. Thanks very much, because when they complain you, and they don't get their costs, or they complain you because there's costs awarded against them, and they want to sue you, you waive that, and that's your na-na-na-na moment, right? That's your defence.